Hi, my name is Ingersol, and I'm a corporate and real estate attorney at the Kroloff law firm. Today I'm going to discuss key considerations in starting a new company. Let's say you've got two software engineers. They're going to be our founders. They've got something going that they think is very interesting. It's a new software idea. They want to form their own company to commercialize it. The first decision to be made, and one of the most important ones, is choice of entity. What kind of entity should they form? Should it be a partnership? Should it be a limited liability company? Should it be a corporation? And if it's a corporation, will it be an S-Corporation or C-Corporation? There are many pros and cons to be considered in making this very important decision. In this particular example, we discovered that our founders will need outside capital to help the company grow. So we decide on a C-Corporation because that's more investor friendly, especially for professional investors like venture capital firms. Now we'll discuss ownership and shares with our founders. Well, they are equal partners, and they want to go ahead and issue all the shares right now, 50-50. But we have to say not so fast. We have to think about this. What happens if in month 8, one of them decides that she has had enough of the startup life and goes back to school to get an MBA? What happens if, God forbid, one of them passes away? Without the correct provisions, the wrong decision here could lead to half the shares going to people not active with the business, and that probably means the end of the company. So they need share vesting. The founders need to earn their shares over time. Okay, now they're 50-50 owners, subject to share vesting. What happens if they don't agree on something and they have a deadlock? Well, we're going to recommend a 3-member board of directors. We're going to recommend that they choose a trusted friend or advisor to be that third person who can break any deadlock. Now let's talk about the intellectual property. Who's going to own this new software product? Well, one founder had the original idea and wrote the white paper for it. The other founder wrote most of the code and came up with the neat logo. Well, the only way forward, and really the only way to get investors, is to have the company own everything. Now let's talk about the state filings that are necessary to get our founders going. The first is the Articles of Incorporation. This forms the new corporation as a legal entity and authorizes shares which can then be issued to our founders. It also names the agent for service or process and allows for the indemnification of directors. This means that if the company gets sued and if the directors themselves get sued, the company will provide for their legal defense. When we issue the shares, we also need to file a Form 25-102F with the state of California, which provides the securities law exemption for the issuance of the shares, and it reports to the state that the shares have been issued and the issue price. We'll also need to file a statement of information. This must be filed no more than 90 days after formation. It will list the officers and directors so that the public knows who's involved in this new corporation. So now our founders are off and running. Thank you for listening.